So, привет, team. That's about it for right now. I'm very happy to be here, and I am going to give a couple preliminary notes before I start into the main presentation. So, first of all, I am happy to share this deck, this PowerPoint deck, with anyone who wants it. If you don't have to sit in the audience and take pictures of the slides, I'll send it to you. And the way you can get it is if you add me on either LinkedIn or Facebook, Gordon Einstein, and send me a message, I'll send you the entire PowerPoint deck. So don't drive yourself crazy trying to take pictures. All right? That's number one. Number two is I'm seeing a lot of ICOs and startups trying to avoid selling their tokens or raising money from the United States. And I understand where they're coming from because people perceive the securities laws in the United States to be very difficult to work with, very complex. I actually gave a 2-hour presentation last night to the Ukraine Bar Association on United States securities laws. And it was interesting because they're very complex, but there's lots of ways to work with them. And I think the audience afterwards got a real sense of what's possible. But as a general principle, whether you're selling tokens or raising money as a security sale, or whether you're selling tokens that are utility tokens, I would argue that it's a big mistake to ignore the United States and not sell into that market. And here's the basic reasons why. And here's why this remains important, even if it's hard to work with the US and US securities law. The two biggest national economies on the planet right now are China and the United States. It's hard to tell who's first because of currency fluctuations and everything else, but those are the two biggest national markets by far. As all of you know, I'm sure, China is currently not allowing ICOs. The United States, and I'll be real clear about this, has not banned ICOs, and the United States has not said that all tokens are securities. So if China is not available, your only other option in the top two economies is the United States. And so it's not really practical to ignore it. There is a huge amount of investment capital and investors in the United States, and I work with them, who want to invest in ICOs, who want to invest in tokens. And if you make use of the law as it is, you can get access to that capital. Also, even if you aren't selling an ICO into the United States, keep in mind that if you're selling a utility token that's not a security, or you're not quite sure, the whole point of utility token is that the customers for your platform are going to use it to gain access to your platform. Well, you really can't have a global platform that's using utility tokens if you don't have American customers, as a practical matter. And if you somehow manage to avoid the American market, someone who comes after you in time, someone who tries your exact same idea a month later, who does manage to raise capital in the United States, who does manage to access US customers, the legal term is they're gonna kick your ass because they're gonna have so much more money and so many more customers that even though they came later, they can still pass by you. So it's all worth at least looking at. And third point is I want to be real clear about something. There's been, some of you follow me in the audience, on Facebook and on LinkedIn and on Telegram, there's all this stuff about ICOs are banned in the United States, or there's a 1-year hold period, or SEC says all tokens are securities. The term for that is FUD, fear, uncertainty, and doubt. As a matter of law, none of that is true. It is just true that the SEC is being careful, the US Securities and Exchange Commission is being careful and loud when they talk about ICOs, but as a matter of law, not every token is a security, and not every token sold in an ICO is a security. And since the time I put this deck together and mailed it in, the SEC has actually made a website on their website. It's sec.gov/ICO, where they say tokens sold in an ICO may, not shall, not are, may be a security depending on the facts specific to that situation. Now, that's actually correct as a matter of US law. So the SEC basically just admitted correctly, so good for them, that not every token is a security and not every token sold in an ICO is a security. So since that's out there, you might as well look at this country with 300 million people, or more now, that's either the first or biggest second economy, size economy on the planet, and see if it's possible to raise capital there and see if it's possible to get those customers. I encourage you, I'm aware of the complexity. I deal with it all day long. It's very interesting. But there's reasons why I think it's worth it. I've actually worked with clients who raised several tens of billions of dollars, coming up on $100 million in the United States. Okay, so that's a big warm-up. This is the Securities and Exchange Commission seal. In the earlier version of this deck, I was just using the seal as it was, but now it says, I am not the SEC. So if anyone in the audience was confused, I'm not with the United States government. So, luckily. Okay. Maybe it'd help if I pointed at, no? Oh, technical support. At the monitor? Okay, thank you. Appreciate it. All right, so as an American attorney, I have to say this. Okay, this is a friendly but real disclaimer, which is I'm a lawyer. I'm not your lawyer, probably, unless we are. I can say yet, and it's nice to meet you. This is going to be fun. There you go. Okay. So for the camera person, I'm going to be kind of walking around a little bit, so you may want to pull out the focus, but that's your call. Here's a general principle. You don't want to be a headline. There's this saying that all publicity or all being in the news is good. That's not true when it comes to the United States government or the law. The top left picture, you can see two gentlemen sitting there looking serious. That was during a United States Senate hearing on February 6th. The gentleman on the left is Chairman Clayton of the United States Securities and Exchange Commission. The gentleman on the right is the chairman of the Commodities and Futures Trading Commission, the CFTC. And between the two of them, they are two of the primary regulators of the financial markets in the United States. Now, this was a hearing in the United States Senate on the topic of cryptocurrencies, blockchain, and ICOs. So why are there two of them? Why is there not just the SEC? The idea is that not every token is a security. Sometimes a token is a commodity, similar to gold, or to cotton, or to corn. So you have securities and you have commodities. The chairman of the SEC was pretty aggressive with his language, talking about ICOs and how he had not seen an ICO that was not offering securities, which actually is not correct. He was wrong. And he was partially aggressive because one of the senators, Senator Warren from Massachusetts, was giving him a really hard time for not doing his job in some other areas. So I think from my point of view, I think he was kind of compensating for that by speaking aggressively about tokens and ICOs. Since these hearings, the SEC has softened its position, and if you look at the website, they're now actually more acting in accordance with the United States law. The gentleman on the other side, so chairman of the SEC, chairman of the CFTC, regulating commodities. When asked about ICOs and tokens, his point of view was, as a regulator, he needs to protect the public, he needs to protect investors. But it was interesting, he talked about how when his kids come home at night, they don't talk about stocks, they don't talk about bonds. all they do is talk about crypto, Bitcoin, blockchain, and tokens. So this guy at home at the dinner table every single night has his kids talking to him about crypto. And so he acknowledged that there's something good happening here and that the regulators in the United States need to be open to what's going on. Going one column over to the top middle, and this is sort of a preview. This is an ICO called Munchie, which you may have heard of. So this was an interesting situation. You had an ICO in the United States that the SEC felt was breaking the law, not as a fraud, but they were not following the law relating to securities in the United States. The SEC did not send in the black helicopters. They did not send in the policemen with masks and guns. They picked up the phone and called these people and said, stop what you're doing, it's probably illegal. And Munchie said, oh my gosh, and they pulled down their website, they pulled down their white paper, all that other good stuff. So think about how strange that is. So I don't know what it's like in Ukraine, but in the United States, if I'm going to go rob a liquor store, the police don't call me up and say, hey, you know that liquor store you're gonna rob tomorrow? Please don't do that while we figure out what the law is. I mean, it'd be nice, but usually the police just arrest you when you commit something, a crime. It's very unusual for an agency to step in advance and make a phone call and say, please stop. That kind of shows that the SEC is trying to figure it out itself and not be too punishing. So Munchie, I think, was an innocent mistake by that ICO, and I'll explain what they did and why the SEC shut them down, but it was just a phone call. There's nothing criminal, they didn't pay any money, it was no real consequences. The rest of this has consequences. When you commit fraud, and I'll explain what fraud is legally. When you commit fraud, and also this is a principle that's true all over the world. When you commit fraud, whether you're selling securities or not, the SEC, FINMA in Switzerland, FSA in England, everywhere will come down on you like a ton of bricks. So this is a Rise Bank on the far right. They were shut down by the SEC, and the people doing the ICO were brought up on fraud charges. The same thing happened on the far right. I think that was RE-Coin. You have a situation here where it wasn't exactly fraud, but the people conducting the ICO for Paragon Coin, which is a coin related to marijuana or cannabis, had a rapper, you know, one of those singers called The Game, that was paid to talk up the ICO, and that's a violation of US law for securities. It's something called touting. Touting is when you pay someone to say nice things about your product, and people trust them like a celebrity, but they don't know that that person's being paid. So it's a way of manipulating the market. The next column over, Tezos, which I'm sure you've all heard of, was not a crime. The SEC did not shut it down, but there's a lawsuit between the founders of Tezos and the Tezos Foundation, and they're fighting over control and profits. So again, I'm gonna be talking about keys to doing a successful ICO. It's not just complying with securities law, it's treating your startup like a startup. And that applies all over the world. Let's go to the next one. Okay, so here's, this presentation is basically a list of 5 things not to do, and you can figure out what to do by just reversing them. Rule number 1, whether it's securities or anything else, but especially with securities. And again, I'm happy to email the deck to everyone. Just add me on LinkedIn. Rule number 1 is don't lie. It sounds very obvious. Lying when you're selling securities is committing fraud. Once you commit fraud, the reach of law enforcement gets very long, and there's real consequences, including potentially criminal consequences. Now, what is actually a lie legally? Okay, I think we all know what a lie is just in life, but what's a lie legally? A lie is a misstatement of a material fact or the omission or leaving out of a material fact that is designed to or will influence someone's decision to buy a security, sell a security, hold or hold onto, hodl a Bitcoin, or not take any action. Again, it's a statement of material fact or leaving out a material fact. Material fact means something relevant, something important, not just a small little detail that any kind of reasonable investor or reasonable buyer would take into consideration, would think about when making an investment decision. So if I say it's a beautiful, sunny, warm day in Ukraine today, I'm clearly lying. By the way, I'm dressed for Puerto Rico. I thought I was going back to Los Angeles. I ended up not going to Los Angeles. I came to Kiev, so this is my Puerto Rico clothing. I wasn't quite ready for this. So if I say it's a beautiful, well, it is a beautiful day. If I say it's a warm day in Kiev right now, I'm lying. But is it material? Did any of you put on a coat because of what I said today or not put on a coat? No. So I'm lying, but it's not material. Okay, a material fact is one, again, that someone's going to take into consideration when making an investment decision. So here's an example. And this is a real case. Imagine you're an ICO, and you say, our ICO is backed by assets. We have $100 million of valuable real estate, gold and diamonds, and it's all true. And you say, buy our tokens because we have money, we have assets backing up those tokens, when in fact, you have nothing. Well, that's clearly a lie. It's material because I certainly am depending on you saying what you said when I make an investment decision. That's fraud. Take example number 2, which is a little bit different. Suppose, and people say this a lot, our platform has millions of active users, and it works, and it's fully featured now. Buy our token. When in truth, you have 3 users, one of them is your mother, and it's the first alpha version. Well, that's obviously a lie. You're kind of exaggerating. You're going beyond normal sales. Exaggeration. Most people exaggerate when they try to sell. This is like clearly such an exaggeration that's a misstatement of a material fact. So that's fraud. The third one is what I think catches everyone. Not everyone, but I'm seeing ICO after ICO having this issue. So imagine the first case. Actually, imagine something where you say, we're doing an ICO, and our token is backed up by $10 million worth of gold. And suppose you really do have $10 million worth of gold. You're not lying, right? You really have it. But you leave out the fact that you owe $100 million. In other words, you have $100 million of debt. Well, you didn't lie, technically. I mean, you did say the truth, but you left out some fact that basically turned the first true statement into a lie. That's an omission of fact. So it's rare for silence to be a lie. If I just stay quiet, I'm not lying, okay? But if I say something that's true but leave out something important that goes against the true thing, that's a lie of omission, and that can be fraud. This is not just made up in my mind. This is our eCoin. It's short for real estate coin. Now, the funny thing is real estate coin actually had no real estate. So there you go. They got shut down with fraud charges by the SEC. This is a Rise bank account. They basically completely mischaracterized what their business model was. It was fraud, and they got shut down. Okay, rule number 2, and this applies whether you're in Ukraine, Gibraltar, United States, or Singapore. You need with the exception of Bitcoin, Bitcoin you can say is truly decentralized or truly distributed. Behind almost every ICO is a startup, okay, is a company behind it. It may be a company, it may be a foundation, it may be a team, but there's some group of people that aren't really distributed and aren't really decentralized. It's a startup. And so no matter where you're starting your company, wherever you're doing your blockchain startup, you have to treat your startup like a startup. Now, what does that mean? Number 1, you need to form an actual entity, whether it's a business, a corporation, or a foundation. And you need to choose select the correct jurisdiction. In other words, the correct company, the correct country, and also the correct form of business. That's number 1. Number 2, and I see this happen all the time, where people don't do this. You need to have written agreements with your founders, the executives, the employees, the advisors, speaking of the last presentation, your board members and your contractors, they need to be in writing. You can't just have verbal agreements. Why? Well, here's where this really kicks in. Consider, really? Okay, always. Consider that blockchain startups and crypto startups, they're technology plays. They're based on intellectual property that you're developing. That intellectual property is coming from someone. They're developing it for you. And even if you're paying them for it, you don't necessarily own it, and you don't necessarily have the exclusive or only rights to it. You need written agreements where they take what they develop and they assign it, or they do it on behalf of you, the company that's paying them. There are many situations all over the world where people hire developers, don't get the results assigned to the company, and the developer can turn around, sell it to someone else, or claim that the original company wasn't using it with permission. So you need to have agreements where you assign that intellectual property. Even if you trust someone, even if you like someone, people die, they get divorced, they get angry, they drink too much, things change. So get an assignment of all intellectual property. Number 4 is think through your tax issues. In most of the world, when you sell a security, you don't need to pay tax. If you sell stock, you don't owe tax on the money. But if you're very clever and you avoid being a security, that opens up the door to you selling a good or a service. Your token, if it's not a security, it's probably a good or a service. In many countries, that's taxable income when you sell that. And even if you're located outside of a taxing jurisdiction, if you sell your tokens into a country that imposes tax on the sale of goods or services, you need to be sensitive to the tax issues. Okay, let's keep on going. So Tezos, again, was a situation where they did not break the law by issuing their tokens, but they did not document the relationships between the founders and the person running the foundation, and now they're in a big lawsuit. Autonomous, these poor guys. So Autonomous, their whole idea was that they were going to build a company, a structure, without using normal legal systems. They said, we don't need contracts, we don't need judges, we don't need lawyers, we don't need law. We're going to make it all work through smart contracts, like a DAO. Well, guess what? The founders of Autonomous are in Singapore court suing each other over the power and the profit. So I guess Autonomous isn't really autonomous. So again, this could all been avoided if they just documented their relationships. Okay, number 3, I think most of us are familiar with Howey and SAFTs. SAFT is a simple agreement for future tokens. The worldwide position on SAFTs is unclear. The United States and Switzerland seem to be here. Other countries seem to be here. But the general idea is that if you're developing a platform, and once the platform is built, the tokens that are going to be used on the platform will not be securities. They'll be utility tokens once the platform is built. If before the platform is built, you sell tokens to raise the money to build it, then between the time you raise the money and the platform working, the token will be a security during this period, even if later, once the platform is built, it will be utility. So I'll say that again. Imagine you have a really good idea for a platform. The platform is not built yet. You do an ICO of tokens to raise money to build the platform, with the idea that once the platform is built, they're going to be utility tokens. They won't be securities. The position, it seems, in the United States and maybe in Switzerland and some other locations, is between the time you do the ICO and the platform working, the tokens will be securities. Well, that's not good. So the way you get around that is you use a document called a SAFT, Simple Agreement for Future Tokens. So simple agreement for future tokens. The idea is these are paper agreements or digital agreements that you sell to certain qualified investors. Okay? They give you crypto or fiat in exchange for these agreements. You take the money that they give you, you build the platform, and then once the platform is working, once it's working, you convert the SAFT, this document, into utility tokens, and then you're not violating securities law. Right? So again, just final point. be real careful about selling pre-functional tokens around the world. You want to do a private capital raise. You want to do a seed round with private investors, raise money with SAFTs, build the platform, and then convert the SAFTs into utility tokens. Again, this is Munchie. Munchie read the law halfway through and then stopped. They should have read the whole law. This poor lawyer, who I think is actually based in California also, wrote this beautiful white paper. It was beautiful, and I downloaded it before she took it down. So she wrote this wonderful white paper about why the Munchie token was a utility token and not a security. She did this whole Howey analysis. You know, it was beautiful, it was wonderful. But the problem is Munchie was selling this utility token before the platform was actually built. They were selling the token to build money, sorry, to get in money to build this platform. Well, the SEC said nope, called them up, said stop now. They took down the website, they took down the white paper, and that's an order from the SEC to Munchie, where basically Munchie agreed to call everything off. So again, do not sell pre-functional tokens to the world. Okay, and this one's very key. Suppose you have a token that's truly not a security, or even if it is a security. You want to be very careful, especially with a token that's not a security, when you discuss the token going up in value. When you talk up the return on investment, the ROI of the token, you know, you're going to get this token for $1 or for €1 or for whatever, and it's going to go up 5 times in value. Well, when you communicate like that, when you market the token like that, what happens is what may be a utility token starts to look like a security. And if you market a token like it's a security, the SEC will believe you. If you market a token like it's not a security, the SEC may believe you also. So you have to be real careful about talking about listing your token on exchanges. Now, obviously, everyone wants their token to be listed on an exchange. There's a good reason for that. You want, even if it's a utility token, you want people to get their hands on the token so that they can use it. But if you talk too much about plans for listing a token on an exchange, you're beginning to create the idea in people's mind that they can quickly sell their tokens for a profit. So just watch out for that. I was actually at a conference, and a gentleman who was doing an ICO was being interviewed by the press, and the press asked him, when will your token be listed on an exchange? And he said, no comment, we don't talk about that. And I want to go over to him and give him a big lawyer hug. And I don't know if you've ever had a lawyer hug, it's bad. But he was smart. Obviously, his lawyer had spoken with him. Don't talk about that you're going to be listed on an exchange. Just let it happen without the public knowing about it, or without the public seeing the process. Number 2 is, in your marketing, don't discuss the fact that your utility token will go up in value. That sounds like a security. That sounds like an investment. The idea is not that your token is going up in value, it's that your token's becoming more useful. The usefulness is increasing. That's not a security. Pencils can get more useful. Be careful about your communications on Telegram, Slack, Twitter. Don't put your intern in charge of that. They're going to say some crazy stuff. And be careful with your discounts and bonuses. That begins to make it look like a return on investment. I'm going to go through this just because we're on the, I won't get to the last slide. Okay, final main point here. All around the world, not just the United States, the SEC, the CFTC, which is for commodities, IRS, tax, FBI, criminal, everyone's looking, including the United States. But again, it's a mixed bag. You can work with the system, and again, I've worked with many companies that raised millions of dollars by following the rules. So be aware that neither agency has banned ICOs. Number 2, it's been clear in the United States that Bitcoin is not a security. So it's been admitted it's not a security. It may be a commodity, but it's not a security. Number 3, and this is interesting, the CFTC, which regulates commodities, has admitted it has no power over what's called the spot market, or immediate trading in commodities. So if a token is a commodity, the trading of that token in the immediate time, not in the future, is not under the CFTC. Also note the SEC said, you all remember the DAO. The SEC said that the DAO was a security, but they did not say that Ethereum was, and they could have. And last note is the SEC has formed a cyber enforcement unit. They're sending out subpoenas, they're doing investigations. I have not seen a single case of fraud or ICO being shut down where the ICO was following the rules. The only ICOs getting shut down are where there's fraud or where they're selling a pre-functional token. So I'm happy to answer questions. I know that was a lot, very high level, but I appreciate all the attention.
Just a second.
Hello. The question is, do you think that the upcoming regulations of the USA, SEC, and CFTC, whether on a federal or on a state level, are going to be such that US-based crypto exchanges like Coinbase, Bittrex, and so forth are going to lose customers and liquidity as a result?
I'm not sure, but let me make a couple of points. The first point is, in the United States, if it's a security, whether it's a token or traditional, unless you're committing fraud, you generally need to focus on the SEC and not so much on the states. Now, of course, you know, it's law, so there's a million little asterisks or warnings about that. But thank God the US has a federal or single scheme of securities regulation, and it's under the SEC. The SEC has what's called preemptive jurisdiction or sole jurisdiction on securities nationally, just like the CFTC does on commodities. So there's, of course, two impulses going on right now. These are conservative agencies. I wish they weren't so conservative because as someone from America, it bothers me that we're not up here with the countries that are being brave and trying new things. You know, but they're conservative. It's just the way it is. But there's a huge interest in crypto and blockchain and everything else in the United States, and people are aware that if they crunch down too hard, number one, it's not going to work, and number two, anyone who has one of these ideas is going to do it anyway. They're just going to do it somewhere else. And they're sensitive to that. They got it. In the United States, every company that gets formed, every big company, is formed in Delaware, the state of Delaware. It used to be New Jersey. Then New Jersey got strict, and all the companies changed their location to Delaware. New Jersey changed its law to be less strict, and no one went back. Okay, it's like you got a divorce and you don't want to get remarried. Okay, so once these companies leave the United States, they're not going to go back, and I think everyone's aware of that. So I think the odds of this being shut down are almost nothing. They're trying to figure it out, and part of my job is to work with regulators, and I'm doing this, to educate them, talk with them, hear their concerns, but then try to address them and work with them to get a good result. But a great question. Thank you.
Any other questions? Okay.
Hello, Gordon. Thank you for the presentation. Can
Thanks.
you elaborate a little more on token taxation laws in the United States? I heard tokens are taxed as assets versus income.
Oh, it gets all fun and complicated. So if it's a security, there's kind of two. The United States does not have VAT. Okay, that's a non-US concept. We also don't have metric either, which is kind of ridiculous, but whatever. If something is a security, then it's going to be taxed as regular income if you held it less than 1 year, or capital gains is a term if you hold it more than 1 year. Okay? If it's not a security, and I had this conversation yesterday, it's something else. But we don't know what that something else is. It depends on the tokenomics of the environment. Okay? That token can represent a software license, a service, a good, a commodity, a payment mechanism, a gift, you know, a coupon. It can do all those things. So there's no, and I think this is correct actually, there's no rule for taxing tokens that aren't securities. You really need to look at what the heck is this thing. Well, right, that's your tokenomics. Your token, and again, I want to make this real clear to the world. When you're trying to decide your jurisdiction, or whether it's a security, or who you're going to have buy your token, all that stuff, that's all great. The first thing you need to figure out is your tokenomics. Your tokenomics and your token design drive all your legal decisions. Okay, it's not the other way around. You come up with your best business model, you come up with your best technical model, come up with your tokenomics, come up with your token design, then you figure out your jurisdiction, then you figure out if it's a security node, all that fun stuff. Let me just throw one thing out here. So imagine your perfect token design has 2 legs and 2 arms. I think I have 2 legs and 2 arms, right? And then someone says, oh no, that perfect token design, it looks like a security. So what do? You say, I know, I'll make it not a security. I'm going to chop off that right arm, and now look, I don't have a security, because these things don't look like a security. Well, that's not very effective, because I just chopped off my right arm. And meanwhile, someone else who's not afraid of the law, who understands how to work with security laws, has a token with a right arm. And when me without a right arm and me with a right arm get in a fight, my right arm is going to win. So design your token to be the best token you can make for your business plan and your technical model. Don't even worry about the category, and don't even worry about tax. Just do the best job. Because no, go ahead.
What if you're on the other end, meaning you made income meddling in tokens, basically?
Well, that's going to be taxable as regular income, either
It
a
is
personal.
still. So
Oh,
I heard
yes.
that you could tax it as an asset.
There's no tax holiday on revenue from crypto in the United States at all.
Okay. So
But
it's still
there's no
income.
penalty either. It's just normal income.
Okay.
Now,
Thank you.
there you
Gordon, thank you so much. I'm really so appreciated to moderate such a great dance floor, because I can't even name in other ways such thing. So thank you so much. Applause.
Thank you, everyone. Appreciate it.